وإن شاء الله تعالى هذه الأخيرة في هذا اليوم، وسيكون هنالك جلسة غدا صباحا الساعة 9. اسمحوا لي أن أدعو. Then we'll start the session number 4. Allow me to invite the speaker, Ms. Ang Santens, Professor Thomas Clay, Mr. Cedric Shaw, Mr. Sami Tammous, and the moderator, our pal Christian Alberti, to come to the stage, please.
And good afternoon, ladies and gentlemen, distinguished guests. It's my pleasure now to kick off the fourth and last session of the first day of SCCA19. We have a very interesting topic today for you to really basically conclude this day with some technical aspects of arbitration, be it content, be it also structure. So as you know, it's no longer uncommon to hear blockchain technology, artificial intelligence, smart contracts in one sentence, and usually then also along with ADR. I'm not suggesting that every technology is always fit for the purpose or fit for arbitration or ADR in general, but you will see that it transcends in many ways into our current life, and particularly also arbitration, ODR, has seen some impact in terms of technology. Now, we have, fortunately, very distinct speakers here today, expert speakers on the topic, who would like to discuss with us today the technology and how technology can actually help us in the courtrooms and the hearing rooms. We will also be talking about how that all can operate in cyberspace. Think of online arbitration, for example. And we will also be talking about experiences in arbitrating tech disputes. And above everything else, we also have to always worry about cybersecurity. Think of hacks, where you lose confidentiality about the process. So we will also be covering this topic in turn. So allow me to introduce the first speaker of today. Ms. Ang Santens is a partner in White & Case LLP's International Arbitration Group. She's based in New York and is licensed as attorney in New York State and as a solicitor in England and Wales. She serves as counsel and arbitrator in commercial, construction, and investment arbitrations around the world. And perhaps most interesting for us here in the Kingdom, she is currently representing the Kingdom of Saudi Arabia in 2 investment treaty arbitrations at ICSID, and has advised Saudi Aramco on a number of occasions. She also serves on various boards of directors. She is also former chair of the CPR Arbitration Committee and a former vice chair of the Arbitration Committee of the International Bar Association. I will spare you all the laudations and refer to the website and the programs to see what else she has done in her life, quite a lot, and rather proceed in order to expedite things in the sense of technology and arbitration to our topic, which is the use of new technology to enhance advocacy and efficiency in the proceedings. Now, as I said, Anke, we have seen that technology really has transcended in penetrated every aspect of our lives, and this hasn't stopped before hearing rooms. So very curious to hear your insights, your experiences as an attorney practitioner in how technology helps you throughout the entire process, start to finish. And I'd like to turn off the microphone to you.
Good afternoon. I would like to start by thanking the SCCA for inviting me to speak this year. The last edition and the first edition, my partner Paul Friedland spoke here, and we at White & Case are very delighted to see the organization grow and flourish and to be there with it along the way. As Chris mentioned, we have a very long relationship with the Kingdom, spanning over 60 years, and presently very involved in disputes in the Kingdom. And we think that the growth and development of SCCA is a key pillar of the 2030 vision of the country. And so we're delighted to be gold sponsor of the conference this year. So as Chris mentioned, I will speak today about the use of technology in arbitration to enhance advocacy and efficiency. And in doing so, I will demonstrate certain technology. And so before I start, I need to make a little disclaimer that I am not trying to market or sell any particular technology. I'm just sharing it with you for the purposes of the of the presentation and to give you a sense of what is out there in the market. As with life in general, these days technology is a part of an international arbitration case from the very beginning until the end. We often hear about a dispute through a phone call or an email message or more and more frequently even a WhatsApp message. And from there, because our clients and the witnesses and the experts often are dispersed in various locations, very often our communications take place through one means of technology or another. And luckily, technology has made very significant advances to enhance communications. Nowadays, we can have a video conference with any of our clients whenever we want and share documents on a screen together and look at documents together through technology like BlueJeans and WebEx. Those have really significantly enhanced the quality of the communications and so reduced the necessity of travel and the attendant costs. So that's one area of technology that I would say is really enhancing efficiency in a case on a daily basis. I wanted to start by focusing on the use of technology and two particular technology tools that we have found particularly helpful with general case management. The first is one that will be very well known to all of you, and that's the iPad. The case docket in an international arbitration, as you've heard this morning, tends to be very big. There are many documents, there are many statements, there are many pleadings. And I used to have a hard copy of the case file, actually two, one in the office and one at home, when I wanted to work on a case at home. And when I was traveling, at some point in time, half of my luggage consisted of hard copy copies of key documents in my cases. And at some point in time, that just became completely unmanageable. It was no longer workable. And so I took the big step of transitioning to iPad. So I now have my entire case docket on my iPad. I have no papers anymore, except when I give a speech. And I have to say, for me, the iPad has been really a life changer. It's something that I think is intuitive to all of us in daily life, and so to be able to also incorporate it in our daily work routine is something that can be very helpful to all of us. There's also an increasing offering of case management databases, allowing large teams to collaborate effectively on a case, including when members of the team are dispersed in different locations. In one of the cases that we are handling in Saudi right now, our team consists of members in Riyadh, New York, Washington, and Singapore. And to be able to work effectively on that case, we need a case management database that we can all access in real time, and so can our clients. And so the most common application in that area, and probably the most sophisticated right now, is called Magnum by Opus. So I thought I would share a little demonstration video with you. Oh, it's missing sound. I guess that shows that technology is wonderful, but it does have its limits. So let me maybe speak a little through it. What the video shows is a database that people can access from their computer all around the world. They're actually creating an app right now so that you can also access this from your iPad or even your iPhone as you go along. You can annotate documents, you can share comments with others, you can put in notes. The notes can be viewed by everybody, or you can make them viewable only by certain people, or you can make them viewable only by yourself. There's a huge amount of flexibility. This is a transcript of a hearing that is being marked up. Documents are connected to it. So there's just a huge amount of flexibility and opportunity to work together and to create a shared case file together. Let me move on because we are missing the sound, and so some of the messages that were in the video. And let me move on to another topic, which is the use of technology in document review. You heard already this morning, the complex arbitration cases tend to involve a lot of documents. More and more, when we handle a case, we will ask the client to give us all the documents in relation to a project, for instance, that is the issue of a dispute. And so there will be many, many documents to review, both for us to be able to build our own case, so to use documents as exhibits, but also because there is something called a document production process, which was also mentioned this morning, where one party may ask the other party to produce certain internal documents that are relevant to the dispute. And so to handle that mass of information, there are, again, sophisticated electronic tools on the market that allow teams to review documents, to search within the documents so that the categories can be limited and less documents need to be actually reviewed. And so I've put as one example here some screenshots from an application that is called Relativity, which we use at White & Case, just to give you a sense of the technology, again, that is out there to help with these very big, massive cases. Another one that I wanted to bring up is machine translation that is really accessible to all of us. As you know, often in arbitration, not all team members and sometimes even no team members may be able to read the documents that are relevant to the case. Sometimes there's a particular little aspect of a project where documents were exchanged in a language that's not known to anybody. And so we found that in the last years, machine translation has become very, very good. Of course, it doesn't replace human translation. The way we use it is to have an initial sense of a document. What does it say? Does it look important? And if it does look important enough, we'll try to find a native speaker or have it translated by a professional translation agency. But I did want to bring this to your attention. These days, you can really just stick a block of text in Google, and out will come a translation that's pretty good, and that will give you some sense of what the document says. So that can be a huge cost saving, particularly when documents are long and only some excerpt may be relevant. In legal and factual research these days, technology is everything. The days of research in hard copy books in a library are really over. I just wanted to highlight two very common resources, online resources for arbitration. One is Kluwer Arbitration, which is a website that is a database for sources in relation to international commercial arbitration. It has a lot of books, articles, and also published awards to the extent they exist. And the second one is Investor State Law Guide. That is sort of the anecdote, the twin to Kluwer, I would say, for investment treaty arbitration. I think you've heard that explained this morning. That is where an investor might bring a claim against the state on the basis of investment treaty. And in those cases, the awards are quite important. They are almost serve as precedent, although they're not technically so. And so Investor State Law Guide has all the cases and can be searched through search term for the cases. And then, of course, there's Google for factual research. I think there's few resources that beat Google. We Google cases every day. We've actually used the results of a Google search as exhibits in a case to demonstrate that something is common, for instance, around the world, with success. So that's an easy one, accessible to all of us. I did want to speak briefly about a fairly new development, which is the increasing development of research tool for arbitration selection purposes. The selection of an arbitrator is arguably the most important decision to be made in any case. And of course, to be able to select a good arbitrator, one needs to have information about the potential candidates. And so there's been an effort in recent years to bring more research tools to the market to help parties who do not know certain arbitrators in person to get more information about arbitrators. There's a number of them, but I wanted to focus today on one that I think is particularly interesting. and that is Arbilex. Arbilex is a startup of a Harvard law graduate who has joined forces with an MIT graduate to use complex algorithms to try to use the past to predict the future. That's one thing they do. That's their predictive analytics tool. They also have a descriptive analytics tool. And that's what this slide shows. So what Arbilex has done is for investment treaty cases, try to summarize information in relation to a particular arbitrator. Here the example is Albert Jan van den Berg, a well-known Dutch arbitrator, and has really consolidated in one place all the information about Mr. van den Berg's appointments in various cases. This graph here is focused on his appointment as claimant. You also have them in cases where he was appointed as respondent, and then where he was appointed as president. And what the graph does is link the various cases in which he has served and showed in which cases he has served with other arbitrators, along with a lot of other information. So this is really quite a helpful tool in that it summarizes and collates all information out there, saving potentially a lot of billable hour time of attorneys and law firms that are currently doing that work. But I think what's the most interesting feature of Arbilex is that it's also trying to predict how an arbitrator might rule in a certain case. Here in this case, there is a claim about a breach of the fair and equitable treatment, or FET, as the acronym is listed there, in an investment treaty case. And what Arbilex does as a service is it does two things in this respect. It will try to predict, based on historic decisions in prior cases, which arbitrators are most likely to find a breach of fair and equitable treatment in this particular case. So there's a list redacted there, because this is a real-life slide of 5 names that Arbilex found were the most likely to come up with a certain result. And what it also does is when you have certain proposals of arbitrators, it will, in the database, it will tell you what they think the result would be if you appointed that arbitrator to a case. So I think this is a very interesting new development. I'm sure many people have questions as to the utility. Cases are unique. And so we'll have to see whether it actually becomes a success story, but I think there is potential. How much more time do you have, Chris? 1 minute? Done? All right, let me very quickly see what else I would like to impart with you. Hyperlink briefs are nowadays very common in international arbitration. Images and graphs and a memorial to emphasize certain messages and bring pictures to the arbitrators can be a very effective tool. Of course, in argument at the hearing, PowerPoint is used all the time. I'm using one now to demonstrate, I hope, the utility of a PowerPoint. It's not to summarize your argument in bullet points, but is really to bring across certain key messages. And I think the final point that I will, that I will go to is actually, again, the iPad, because I think that is another very practical piece of advice. We now do all of our hearings with iPads. We no longer have hard copy documents at the hearing. We will agree with the other side to make iPads for the tribunal members and the witnesses, and so the witnesses will navigate the documents on an iPad rather than a hard copy, which really can save a lot of cost and also save the inflexibility of preparing hearing bundles so that you can really take a witness anywhere you want in the case record at any given time. So that brings me to the end. I know I've already gone over time. I guess my final message is technology is exciting. I'm sure we'll see much more to come as technology develops over time. On the one hand, the tools that are out there can make our lives more complicated by making cases ever more complex and bringing ever more data to the fore. But on the other hand, I do think there's also a number of advances that can help us reduce that same burden and to highlight what is really important and what in the end really matters in a case. Thank you very much.
Thank you, Anke, for your very thoughtful presentation. And indeed, I guess a couple of years ago, you would say that Google was not necessarily a platform you would use for legal research. I agree with you. These days, Google is just right there front and center with any legal research. Don't cite me on this, but this has been frequently been used for the initial research at least. I was also very impressed by some of the slides you have showed about Opus 2, I think it was, how much technology has really now found its way into document production, or even sharing documents among team members, commenting, sending them back, uploading them, downloading them, in any direction that you can go. Hearing rooms themselves also, I mean, I remember my first day where I walked into a hearing room, it looked like NASA's Mission Control Center, screens everywhere. So again, technology is really everywhere. But again, Ank, thank you. I hope we can talk more about this in your Q&A session. We will take questions at the very end, and we'll hopefully find more angles to discuss this very interesting topic with you. In the meantime, we will like to move forward with Professor Thomas Clay, our next speaker. He's a professor of law, lecturing on arbitration, ADR, and procedural law. He's also the former vice president of Versailles University, an honorary director of the LLM program in international arbitration and business law, and the former dean of the law school of Versailles University. He also acts as attorney and arbitrator under the umbrella of Clay Arbitration. He has sat as chair, sole arbitrator, and co-arbitrator in numerous domestic and international and ad hoc institutional arbitrations under the auspice of various arbitral institutions and rules. Perhaps most interesting for us today here, he has also chaired a working group as part of the prominent think tank called, and I'll pronounce this correctly in French, Le Club des Juristes, that has published actually the report, ironically called Online Arbitration, his very topic today. So I'm very excited to invite Professor Thomas Clay up here, and as an expert on online arbitration, to give us your thoughts, where we stand, and where things go from here. Thank you.
Thank you. Thank you very much, Christian. First of all, of course, I would to sincerely thank the organizer of this wonderful Congress and express my pleasure to be here today with you. I am delighted to be in Riyadh here among you to speak about the very interesting topic, the impact of new technology on arbitration industry. This conference is extremely welcome and provides us an opportunity to explore how to integrate these changes into our practice without deforming it. I am myself honored to contribute to this debate, as I have chaired an official working group, Christian just mentioned it, in France, that has submitted this year a report on online arbitration, which will be the subject of my presentation today. This working group was part of a think tank called Club des Juristes, a lawyer club, and that conducts a prospective reflection on legal issue and brings together professionals from various backgrounds, judge, attorney, professor, and company representative. I can show you this report. It's free of charge, of course, and you can, if you want, you can download on the website of the Club des Juristes. Before going into the analysis of the impact of new technology on arbitration industry, and especially regarding online arbitration, it would be best to focus the scope of the study, which means agreeing on its terms. I will not, of course, define the word arbitration or the word industry because they are already well done by everybody. But the term impact refers to the action of something coming forcibly into contact with something else. Here, I assume that the two forces colliding are, on the one hand, new technology, and on the other hand, arbitration industry. First, online arbitration consists of a private jurisdictional method for resolving disputes by digital means. In our report, we understand online in a broad sense. It means any digital process from the simple electronic exchange of documents within a classical arbitration proceedings to procedures in which the arbitrators are purely or simply replaced by algorithms generated by artificial intelligence. First, online arbitration. Second, new technology is a very subjective concept, as what may appear, for example, to me, very new, may be regarded, for example, by my son, not very old. It is therefore necessary to establish the time window I will addressing here today. From the use of the term impact, one can assume that the time window in question is very narrow and refers to a specific moment. There is no hint here about when the impact is supposed to happen, what is in the past, was in the past, the present, or is it supposed to happen in the future. My opinion is this impact has not happened yet. Therefore, I will address the subject with the assumption that we are talking mostly about the future. It is then necessary to address the subject with a time-bound approach, developing on the one hand what is already available regarding online arbitration today, and in the other hand, what is expected to develop in the near future. Let's start with the modest reality of online arbitration today. With the birth of online arbitration, large arbitration institutions attempted to integrate its procedure into their operating mode. This was notably the case of the World Intellectual Property Organization and of the International Chamber of Commerce. I will focus on the practice of the ICC, because Cedric will certainly tell you more about the WIPO. The ICC has looked at online arbitration only in a very limited manner. It combines the traditional arbitration procedure with the new technology while adapting it to these new possibilities, but in a fairly limited manner. Indeed, in the arbitration regulation in effect during any arbitration via ICC, reference to this question is only made once in Appendix 4 of the regulation that deals with techniques for managing the procedure. In this document, ICC offers the possibility for the parties and the arbitral tribunal in an effort to manage the costs of the procedure of using information and exchanging communication online, whether between themselves, with the arbitral tribunal, or with the Secretariat. As such, while ICC asks the parties to use information technology so as to better manage the procedural costs, it only appears to consider this technology as support for the arbitral procedure and not an arbitral procedure itself. We have the same approach in the most recently rules at the 2018 rules of the SCCA, this one. The Article 21.3 of these rules takes in account a very precise manner the electronic exchange of documents, looking for the best way for an efficiency of arbitral proceeding. This is therefore a question of arbitration being assisted by new technologies rather than arbitration being performed digitally. Accordingly, the ICC or the SCCA's offer is indeed mixed, since it proposes classical elements of the physical arbitral proceeding as well as elements of an online procedure to optimize the process. Classical arbitration actors are gradually beginning to turn to online arbitration while including it in their operating method. But at the same time, some actors making an apparent with this new method of online dispute resolution, a clear difference can nevertheless be noted. Classical and established arbitration actors tend to offer mixed solutions. This means that arbitration solutions are assisted by digital technology, as we have seen with the ICC rules, but at the same time, the new actors tend to develop arbitration solutions that are performed by digital technology. With regard to digital technology performing arbitration solutions, practitioners are far from unanimous. Some reject both the principle and the application. Nevertheless, we see that online arbitration centers are emerging in France, of course, but around the world. These actors, while new in terms of their form, are quite classical in terms of content and can be classified according to their dispute practices. Some, in fact, offer a very generalist platform and are quite concentrated on business law in general, while others are promoting much more targeted initiatives. The question here is always the one of a fair trial. The adversarial principle, for example, that must be translated into IT terms, so that the dispute resolution platform remains compliant with these essential rules. In the end, the existence of online arbitration today is undeniable. In reality, the practice remains limited by the small number of referrals to existing online arbitration systems, which leads one to believe that at the present time, online arbitration still only represents a modest reality. But for how long? And what could come next? The question leads us to the second part of this presentation, the potential revolution of online arbitration in the future. The main question is if it is really possible to replace man by a machine, and the arbitrator by artificial intelligence, a sort of arbitral machine. While perhaps possible, would this be acceptable? This is an alarming question I want to ask now. I mean, are we, the arbitrators, meant to disappear? The first question that arises relative to algorithm justice is that if its ability to change opinions, to decide the opposite of what has been decided before by other arbitrators or judges in similar circumstances, or at least to deviate from the majority trend that can result from existing decisions. I believe that this ability to modify solutions, often called legal uncertainty, reflects the very essence of justice. In other words, a fundamental ability to adapt to a changing situation. It is fairly improbable that artificial intelligence may be able to deviate from the considerations that resulted in its design, that are essentially based on a study of what already exists. It is even less likely that it will attain a level in which, in a totally independent matter, it may decide at a given moment to issue a ruling that is opposite of previous rulings. Thus, the programming methods for algorithms raise doubts as to the ability of such a solution to be innovative, or quite simply, to contextualize precedents in order to make the best of them. The last concern I will address today is the independence of arbitral entity, or the paradox of algorithm arbitration. Independence is at the very heart of arbitral justice, and algorithmic justice must offer the same guarantees if there is to be any prospect of replacing it. Questions of independence of the algorithms are not limited only to the function of rendering justice or making decision. To guarantee this independence or this integrity, the specifications of the technical solution must be agreed upon by the parties or, at the very least, known to them. In theory, absolute transparency is the only guarantee which currently make it possible to ensure the absence of any kind of bias from algorithmic justice. This transparency should ideally also apply to the operating foundation of the algorithms and to the manner in which the latter reason abstractly at the very least. Last point. Also, to ensure the arbitrator financial independence, the identity of all parties having a direct or indirect financial interest in the algorithm design, modification, and operation must be disclosed, as well as any possible links between them. Unfortunately, in practice, this would be extremely hard to achieve. The first difficulty relates to the ability of the parties to understand the programming choices, as most people are simply not programmer computers. Another disadvantage in that such transparency would go against the interest of the technical solutions provider because it would disclose protected matter. Unfortunately, we will not have the time to address all the concerns raised the arbitral machine in this presentation, but as a conclusion, if algorithms succeed to solve the issue I have raised, there is no doubt that there will be a real impact of new technology on arbitration industry, maybe comparable to the impact that occurred 66 million years ago between a meteorite and Earth, which resulted in an extinction of dinosaurs. No need to mention that in my example, dinosaurs would be the arbitrator. Thank you very much.
Thank you very much, Thomas, for this very thorough analysis on the status quo of online arbitration and what the challenges are that lie ahead. I find it particularly interesting, and you hear this quite often, this dilemma between machine and human. And as you correctly mentioned, the challenges that come, of course, with this dilemma. Adaptation to uncertainty is certainly something where machines, I like to believe, still have to struggle with, AI or not. And the other question you raised correctly also is independency. How does a machine know what does independency actually mean? So there are very interesting challenges ahead of us in terms of online arbitration. That is not to say it doesn't happen. In fact, the SCCA, as you may know from my presentation earlier, has now also its online dispute resolution protocol and ODR portal. So we run 100% arbitrations online. But it is indeed a challenge in certain ways, and we always have to be sure that the arbitrator gets not completely replaced until we are very safe that a machine actually can do that. But I think we're still a long ways away from that interesting thought. Now, our next speaker is Mr. Cedric Chow. He is with Chow ADR. Before, he was a partner at a global firm where he founded and led the international litigation and arbitration practice and served as the US head of international arbitration practice. He has led teams in arbitration proceedings around the world under various institutional rules and has sat as presiding sole and wing arbitrator. He received various prestigious laudations and is the co-author of the chapter on mediation in Thomson Reuters, Leading Treaties, Business and Commercial Litigation in Federal Courts. Mr. Chow is a US member of the ICC Arbitration Commission and previously served as one of the 31 advisors to the American Law Institute project to draft the restatement of the US law in international commercial and investment arbitration. He also serves as the AAA ICDR Counsel and was recently named to the co-head of its International Advisory Committee. So Mr. Chow, Mr. Cedric Chow will be covering today another very fascinating topic that addresses that arbitration is not equal arbitration. His topic will be arbitrating technology and IP disputes. And Cedric, in an earlier email conversation we had just last night before you came having the longest ride to Riyadh, we finally, I think, settled earlier today. You mentioned something that tech companies bring different concerns, in a sense, and perspectives to arbitration. And in fact, these concerns, and if you want to call it that, wariness, which you called in one of your articles, towards arbitration can be quite specific. So I'm very interested to hear from you what concerns are out there and how do you perceive this entire subject matter. Cedric?
Thank you. Technology panel, I have to know technology. Thank you, first of all, to SCCA for organizing this wonderful conference and for inviting me. I'm very proud to be here. Thank you to the audience for sticking it out after a very big lunch. I bring you greetings from a faraway land known as California. 45 million people. If it were a country, it has the 5th largest economy, behind the US, China, Japan, Germany. One reason for its economic success is technology. And there are technology hubs around the world, but through a very interesting confluence of factors, many technology giants are in California. First generation Hewlett-Packard, Cisco, Oracle, Intel for semiconductors, Apple computers. Life sciences is becoming more important in the future as people age. Genentech, Gilead Sciences, 2 of the leading semiconductor design firms in the world, which are not household names, but are very large. Applied Materials, Western Digital. And then the latest generation, social media, Facebook, Google, Twitter, LinkedIn, and then I call the disruptors, the disrupting traditional industries. Tesla with the electric vehicle, Uber, Lyft, disrupting the taxi industry, Airbnb, disrupting the hotel industry. All these companies are within a 1.5-hour drive of San Francisco. Let's talk a minute what I call the technology ecosystem. What does it take to have a gathering of technology companies? First and most important, you need the scientists, engineers, inventors. And you need a pipeline. And Stanford and Berkeley are both close by. Financial support. Who invests in your brilliant idea? You have the brilliant idea, how do you get going? There's venture capital. As you get larger, you got angel investors. As you get larger, then private equity. And so there are some very famous areas, both in San Francisco, but also in Silicon Valley, where there are many companies who are on a look for brilliant ideas. And they often say that out of 10 investments, they expect 2 or 3 to fail. They expect 3 or 4 to be middling, and expect a couple big hits like Google or Uber. Besides that, legal support, near and dear to our heart. I won't go through all these different types of legal tasks, but they are very specialized so that people, they'll just be a patent prosecutor. They have a science background. All they do is read the patents, decide whether you can or cannot apply, but all the way down. The last part is of relevance here is I call it the IP litigation. And in Northern California, there is a court system where the judges are so accustomed to technology disputes that they become a very welcome alternative to arbitration. We'll talk about that in a minute. As an example, Samsung and Apple, they fought competing claims of patent validity, infringement, ownership over the smartphones. Those litigation, they kept going on and on and on, trial court, appellate court, back down to trial court. My former firm, Morrison Forster, was representing Apple in that fight. At the height of it, you'd have 100 lawyers on each side, full-time, going at it. So the judges there are accustomed to that type of fight. What else is necessary for the ecosystem? Culture. A culture promoting creative thinking, risk-taking. One says that one cannot be afraid of failure. In fact, amusingly, sometimes when somebody starts a company, entrepreneur, brilliant idea, but fails, that becomes a badge of honor. It meant you were thinking outside the box. Maybe you were a little bit too early, but it has to have a culture that you take risks and don't be afraid. Now let's turn to that central part of the talk, which is technology and their embracing or not embracing arbitration. There was a study by Queen Mary several years ago where they canvassed the corporate council of different industries about different sectors, about their acceptance of arbitration versus court litigation. The energy sector, the construction sector, very high acceptance and preference for arbitration. The financial services industry still preferred arbitration, but less so. They did not survey technology. Had they done so, however, I'm sure that would have been the lowest level of acceptance. And why is that? Why is that? First, there's a fear of losing the crown jewels. When you have a technology dispute, it isn't just a matter of how much money do you owe me for breaching a contract. It could also go into the ownership of your IP, validity of the IP, and so the result could have ramifications beyond the dollar value. And for a technology company, the technology is the crown jewel. Second factor, which is related, is, as we all know, there's no right to appeal from an ordinary error of law or a mistaken reading of the contract. That scares technology companies, because what if the arbitrator gets it wrong? What if an arbitrator who has not been vetted by judicial committees gets it wrong or doesn't like you? What's your avenue from there? Third, and there have been some early days, there have been some arbitrators who were very prominent. They knew arbitration, but they did not know technology. And there were some results that some of the companies felt was wrong. And it's a very tight community. All the corporate counsel talk to each other. They have Silicon Valley Association General Counsel. They come back and say, you know what happened in our case? So these are some of the reasons for their wariness. Now, just a word of sort of definitional. What type of technology disputes are we talking about? Patent validity and infringement, I think of that as very science, very engineering oriented. Those issues will come up and you need experts. You need lawyers who understand the science of it and the patents, and you need the arbitrators to understand that. Patent licensing disputes, I have the invention, I license it to some other company that then commercializes my invention. Those tend to be more contractual, more accounting, and don't necessarily go into the validity of the patents. I think trademark and then copyright infringement, everybody has a good sense of that. Theft of trade secrets are very fact and credibility oriented. Now, over the years, I've talked to a number of technology companies, or advised them, both in drafting their contracts and in advising and actually representing them in court or in arbitrations. What I've seen is over the years is a gradual increasing acceptance of arbitration. And I give talks in-house to legal departments. And I say to them, I understand your wariness, and I would not necessarily push you into domestic arbitration because you have the US court system. But it's a different world. You're going overseas. And if, for example, if you go to China, do you want your dispute decided in the courts of China? And conversely, do you think your counterparty from China wants to be in front of an American jury? And so what you really want, and even if we're not going to China, but we're going to one of the European countries where they might well recognize U.S. court judgment, you still have an issue of a level playing field. The French company wants you to be in the French courts, you want to be in the U.S. courts. Both sides are trying to get tactical advantage. Level playing field. Enforceability of the award. In some instances, the U.S. court award will be enforceable in other countries, such as the UK or Canada and most of continental Europe. But there are other parts of the world where a U.S. court judgment is not enforceable, so you have no alternative: arbitration. Confidentiality. Confidentiality for technology is very important for many. They don't want their trade secret. They don't want their thinking on the next invention. They don't want that out in public. And with arbitration, that's easier. It's possible in courts, but it's easier in arbitration. Now, expert arbitrators in other courts outside of the technology hubs in the United States, if you end up in a court in a rural area or some other states, your judge may not be, probably will not be, as expert or knowledgeable in technology issues. In arbitration, you can specify in advance or at the time that you want somebody with certain areas of expertise. Name the industry, name the technology, how many years of practice. And as this audience well knows, one of the selling points of arbitration always is greater speed, lower costs. I say in theory because, in fact, arbitration, as Toby Landau pointed out, arbitration isn't always fast. It isn't always cheap. But in theory, it should be. And the last factor is not well discussed, not often discussed, but limited precedential value. The arbitration award governs the parties before you. And if you, the company, are worried about an adverse award and having implications beyond your party, then an arbitration sits well. So there have been discussions that I've had actually with some institutions about what can the institution do to attract more technology disputes? What can the institution do to sell themselves, sell arbitration, sell themselves to these big tech companies? And we've paid visits to some of the companies in California. The first bullet point, emergency arbitrators. This is not a new, not an innovation. People have all heard of this, but it actually applies very well to technology, because in technology, things are moving quickly. They don't want to slow down. And if there's a long period of time between the filing of the demand and the constitution of the panel, emergency arbitrators can hear applications for provisional orders or attachments. And that can be very, very helpful. The second bullet point is quite controversial, not well accepted, but people are discussing it. Internal review of adverse decisions. Remember, we discussed how one of the hesitations of technology companies is, what if the arbitrator gets it wrong? And the theory of arbitration is, well, you get one bite at the apple, not two bites of the apple. It's cheaper, it's faster, you bought into that. Well, a lot of companies will not buy into that. They're just worried about that. And so to some institutions, the ICDR is one of them, allows you at the parties to put in a provision for an internal review of adverse decisions. You have to put it in the contract at the beginning, but if you don't, the party that loses under certain circumstances can say, I would like an independent panel of arbitrators from this institution to review the first arbitrator's decision. Third bullet point, we've seen this with the ICC, we see it with the ICDR and other institutions, expedited arbitrations for small dollar disputes. This turns out to be very helpful for small, innovative companies. They don't have much money to play with. They don't want to spend a lot of money. And the court system, at least in the United States, is not well set up for small disputes. Small dispute, big dispute, you have the same procedural requirements that all cost money. Another potential modification, it's really not a modification, but it's more oversight of this promptness of the arbitrator's work. We see that with many of the institutions, and I think that will help bring technology companies along. And finally, last bullet point, technology arbitration panels. Some of the institutions, recognizing this expertise is necessary, have created panels of arbitrators who say that they have a lot of experience, and they put that forward. So thank you very much for your attention. I look forward to any questions later on.
Cedric, thank you very much for your in-depth study of how this industry sector thinks and operates. It's very fascinating to get this insider knowledge from your perspective to really see the problems that general counsel face when it comes to tech disputes. They're not just any other arbitration. Yes, granted, there will be a lot of similarities. But as you said, crown jewels is something very unique to the tech industry. If you have an innovation and you have to protect it somehow, then you have to decide as a general counsel as to how any dispute shall be resolved. You think very hard what kind of ADR process you're going to go with. So you want to be comfortable that, again, your crown jewels, your innovation is protected, or at least you have access to justice in a way that satisfies you, general counsel, and most likely the shareholders. Now, you also have mentioned gradual acceptance of arbitration. In fact, those panels you mentioned last is what is on our agenda, for example, as well, to at some point really go deep into the roster and see who do we have that really truly qualify as tech arbitrators, and create special tech force, whatever you want to call it, teams or rosters or panels within the roster just for tech arbitrations, to really address that concern, that need the industry has to ensure that if you opt for arbitration, you get the best possible choice in terms of arbitrators you could possibly have. Now, moving on to our last topic, we have one more to go, and it's a very exciting one in my eyes. Sami Tanus will be addressing in a moment cybersecurity. So Sami Tanus is a partner with Freshfields Brookhouse Dieringer LLP based in Dubai. Before relocating to Dubai, he was actually working in the Freshfields office in Paris and London. He is an international arbitration specialist focusing on international commercial arbitration and investor state arbitration, and also sits as an arbitrator. He has presented clients in international arbitrations under all major arbitration rules with seats in London, Paris, Dubai, the IFC, Geneva, The Hague, and Washington. And he advises clients on disputes in a variety of industries, sectors such as oil, gas, banking, real estate, obviously technology, travel, media, and construction. Now, Sami will be covering quite a daunting topic, I would say, that is cybersecurity. We have seen many occasions in the past where hacks have been successful with regard to big industry giants, consumer giants of sorts. But we also have seen the first impact on the arbitration industry. So cybersecurity and cyber warfare, if you will, have become a hot topic and also in international arbitration by now. We've seen that happening to an institution, that the concern is always confidentiality. And we have seen this also happening with a law firm, where a communication breakdown is probably one of the biggest disasters a law firm can have. So Sami, I'm really much looking forward to your presentation on cybersecurity in international arbitration.
Good afternoon, and thank you, Christian. Thank you to the organizers of the SCCA conference this year for inviting me to speak. It's a pleasure to be back in Riyadh. And thank you to all of you in the room who are still here. This is the last topic of the day, and I promise I will keep to my 15 minutes, and I will actually take my watch off to make sure I do that. I will be speaking today about cybersecurity in international arbitration, and this is a subject matter that has often been met with some skepticism by arbitration practitioners who question its relevance to the industry. And like it or not, cybersecurity is in fact an issue of critical importance to the continued confidence of users of international arbitration. And I will spend the next 15 minutes or so explaining why and what is being done about it. But let's begin by looking at cybersecurity in its global context. First of all, what are we talking about? Well, when we talk about cybersecurity, we refer to the means by which digitally stored information is protected from intrusion by those who are not authorized to have access to that information. And not a day really goes by anymore without some kind of cyber story being in the press. We have up here on the slides a few well-known examples you will all have heard of. WikiLeaks is probably the most well-known. They've become known for obtaining and releasing classified government information. And as we'll see later, that is actually the use of WikiLeaks information is something that comes up very regularly, particularly before international investment tribunals. Mossack Fonseca was a law firm in Panama that was the target of a massive data breach leading to its clients' information being stolen, and that became known as the Panama Papers that you are well aware of. When Marriott Hotels acquired Starwood Hotel Group, what they didn't appreciate they were doing was acquiring a 4-year-old hack that had taken place a few years earlier in Starwood, which ultimately led to the information of 500 million guests being published, and Marriott faced a £100 million fine as a result of breaching the EU General Data Protection Regulation. And finally, Sony was allegedly hacked by North Korean government, who then leaked unreleased movies. Perhaps not the most serious of hacks to those of us who like movies, but nonetheless important to Sony. But these are just the public examples we know of. But the reality is that these kind of issues are happening every day. And cybercrime has been described by the CEO of IBM as the greatest threat to every company in the world. Now that's a pretty stark statement, but given who's making it, I think we should all pay attention. There are trillions of dollars at stake, according to a number of reports, and our clients are facing are seeing the impacts of cyber attacks on a daily basis and seeing the costs of that on a daily basis as well. It has become a daily reality for many of our clients. And that has led to many of most corporations who are now alive to this issue taking it very seriously, because there are huge liabilities, both from theft of financial information, losses of trade secrets, business interruption from ransomware attacks, for example, and of course regulatory fines. And our clients, there is now such a level of sophistication amongst hackers is that it's accepted by many regulators that you can't actually prevent, in many cases, certain types of cyber attacks. It's just a reality that at some point, if someone really wants to get into your system, they will get into your system. That is why regulators now are focusing more on how you actually respond to a cyber attack, as opposed to just how do you try to prevent it. And we see that here in the Kingdom as well. In the last couple of years, we've seen the creation of the National Cybersecurity Authority, which is looking at cybersecurity issues in the Kingdom as well. Now, what is all of the relevance of all of this to arbitration? Well, the fact that our clients are subject to this issue and are affected by this issue means that the different actors in an arbitration will necessarily be be affected as well. And it's pretty uncontroversial that most arbitrations, and particularly high-stakes arbitrations, will involve the exchange of particularly confidential and sensitive information. That can range from seismic interpretation data in an oil and gas dispute, trade secrets in an IP dispute, pricing information in a gas pricing dispute, or simply your margins in an ordinary commercial dispute. This is very sensitive information that your competitors will want to get their hands on, or hackers, or whoever it may be. And while most arbitrations are supposed to be private and supposed to be confidential to the parties, obviously, as you will all be aware, there are many interlinked parties and actors with access to that confidential information. There are the parties themselves, of course, there's the tribunal, there are experts, there are institutions, there are lawyers, and there may even be courts at the seat or at the enforcement stage through the award. And the reality is that the effectiveness of cyber protection within the confines of an arbitration is only as strong as the weakest link in this chain of different actors. And any of these parties may become a prime target for a cyber attack. Now, again, you may be asking yourself, and I asked myself this question when we first started discussing this topic, is this really a risk that's going to affect us? Don't cyber criminals really have anything better to do than to try to target international arbitrations? Well, a recent study that was conducted earlier this year revealed two important points. First, the vast majority of participants in international arbitration actually acknowledge that cybersecurity is an important issue that needs to be looked at. But more important than that is that 11% of respondents indicated that they had direct experience of a cyber breach in the context of an arbitration. Now, 11% may not sound significant, but I would suggest that it is, and that number will only likely increase if we don't pay attention going forward. And of course, the issue with arbitration is the process is not, particularly commercial arbitrations, is that we won't not necessarily have visibility over exactly what is happening and whether cyber breaches are taking place. These won't necessarily all get into the public domain, so there may well be things happening out there that we are unaware of. So what are the key considerations? I won't go through all of these. I would actually suggest to focus on one of them, which is that although to date there have not been many high-profile cyber attacks in the context of arbitration, there's one that Christian referred to earlier, and I'll come to that. It's a question of if, not a question of, it's a question of when, but not if it happens. And when these things do start happening, and when confidential information does start being released from private arbitrations, it will undermine the confidence in the process. Users ultimately rely on privacy of the proceedings and the confidentiality that comes with the process. Major corporations in particular, frankly, just don't want to have their dirty laundry aired in public. And as soon as you undermine that trust in the process, you undermine the attractiveness of the process itself. There are also reputational issues, obviously, for the users, for tribunals, for counsel, who are targets of these kind of cyber attacks, and potentially regulatory consequences as well, as regulators become more interested in the protection of not just personal data, but confidential data well, other types of confidential data. So what is being done about it? Well, at the end of last year, there was a draft cybersecurity protocol that was published jointly by ICA and the New York City Bar and the Institute for Conflict Prevention and Resolution. And what this is intended to do is to provide a framework for parties and arbitrators to consult and to come up with reasonable cybersecurity measures at hand. Now, this protocol has no binding force. It's very much soft law, to add to the mounting list that Toby referred to earlier, akin to the IBA guidelines. And it's something that is suggested in its Schedule A, is referenced in arbitration clauses if parties want to have regard to it. And the way the protocol has been designed is that it's guided by a risk-based approach, which means that parties will need to actively consider at the beginning of an arbitration, ideally, what are the particular cyber risks they face because of the nature of the process, etc., the nature of the parties, and then to devise either together or with the tribunal appropriate measures to counteract that risk. So let's look at just some of the key provisions. I won't go through all of them, but just focus on a few. You have Article 4 here that recognizes the tribunal's authority to determine the security measures that are reasonable. The commentary to this article, of course, states that even though the protocol says this is part of a tribunal's inherent powers in any event, and that's probably right, but the reality is that unless you adopt this kind of thing, tribunals are rarely ever going to turn their minds to this issue unless prompted by the tribunal. Article 5 recognizes also the important role of the institution in the process of ensuring cybersecurity and the need to adapt also to individual institutions' processes. And many institutions we know are actually looking at this issue at the moment. And we're likely to see more of these bespoke cybersecurity protocols coming out on an institution-by-institution basis as well. Here we have Article 6. I won't dwell on it, but it goes through the kinds of things that tribunals and parties will need to consider when establishing cybersecurity measures, such as the transmission of information, communication, storage of information. But importantly, it covers the point I was mentioning earlier, which is also looking at monitoring the vulnerability of breaches, so identifying breaches, and also who do you notify when a breach occurs and when you realize that information in the arbitration has been compromised. Arabic. Well, doesn't matter. I'll keep going. Here we go. Okay. Apologies to the English speakers in the room, but I will describe what's on the slide. So what is up here is also, there's a reference here to the IBA cybersecurity guidelines. This is another set of guidelines which is a little bit different because they're geared primarily at law firms rather than the users of arbitration, and that gives guidance on the technological measures that law firms need to put in place in order to avoid compromising data safely. And this leads to an important question, which is who is actually responsible for cybersecurity? Is it the law firms, or is it their clients? Is it the arbitral institution? Is it the tribunal? And again, the survey I mentioned earlier by BCLP looked at this and asked the question, and the results were relatively mixed. You had a 21% of people saying the tribunal, 31% the institution, and just under half saying that it's the parties, which you can take to mean, in many cases, the law firms that are advising them. And each of these actors have obviously their role to play, and there are pros and cons for each. So, for example, I think it can be said with respect to tribunals, there are some international arbitrators who are not necessarily known for their technological prowess. Sometimes it's a generational issue. Are they really the right people to be starting or to focus on this discussion? They don't necessarily also have the technological knowledge to identify the right measures. Parties obviously have a role to play, particularly where there is sensitive data in place. But again, if you put law firms at the forefront of that who are advising their clients, frankly, most law firms are not known to be at the forefront of cybersecurity themselves. Just last week, there were articles in the English legal press about 4 law firms in the UK that had been targeted by hackers. And law firms are now seen as in many respects, as easy targets by cyber criminals. And finally, you have the institutions who, in my view, are actually best placed to start the conversation. But there are commercial considerations at stake as well for institutions. You don't want to impose cybersecurity measures that are so onerous that they push parties to use rival institutions. The reality is that this is a shared responsibility requiring active engagement by all of the participants in the process. But this is where I would suggest that perhaps not enough is being done. Soft law instruments like the cybersecurity protocol that we saw earlier are an excellent starting point and a very well-considered means to start that conversation. But it will likely take many years before these issues are raised on a routine basis in international arbitration. And there's also a risk that the risk-based approach leads to constant applications being made at the first session before tribunals as to what is the right level of cybersecurity to have within the confines of the arbitration. And let's face it, the last thing we need in arbitrations is more applications being made. And so I would suggest a slightly more, a combination of soft law tools and a more systemic and mandatory approach is what is really needed. The way we exchange information within the confines of an arbitration needs to be looked at as a whole and in the round. And in my view, institutions need to drive that forward and have a critical role to play by not only imposing minimum standards, but by facilitating the implementation of suitable measures that are applicable to all arbitrations. I will end very briefly with a description of the example I think Christian was referring to earlier, which is one known cybersecurity incident which occurred in an arbitration between the Philippines and China relating to a maritime boundary dispute. And this is where the Permanent Court of Arbitration that was administering this dispute had their website hacked, and particularly the page relating to this dispute. And what's been suggested is that the purpose of that intrusion was to look for IP addresses that had been accessing that website. And off the back of that, the Philippines Department of Justice was affected by malware about a month after the PCA had issued a request for further information from the government. And also the law firm representing the Philippines was also the subject of an attack. Now, you can draw your own conclusions as to who might have been responsible for that, but the point is that this is happening. It has happened, and we are likely to see it happen again. And very briefly to end, and this can be the subject of a presentation on it by itself, so I won't dwell on it, but obviously the issue of cybersecurity and the issue of evidence that is obtained illegally is a whole different conversation. That has been the subject of some debate already before investment treaty tribunals in relation to WikiLeaks documents, but we are likely to see this issue come up again and again as more and more information out of cyber attacks is used in international arbitrations going forward. I hope I've kept to my time, but thank you very much for your time.
Thank you very much, Sami, for an excellent presentation. It is indeed really happening and it cannot be ignored. In fact, I can tell you from experience, many institutions are actively looking into this. Law firms are all over it, so you're absolutely right. It is a live issue. It is a serious issue. It's a vital issue. It's an existential issue as well, because confidentiality, as you know, is one of the pillars of international arbitration. If we say we keep it confidential, then we have to put our money where our mouth is. So absolutely essential here. The last point you've raised is indeed, I think, conference filling, and that is, what do you do if you obtain evidence through a hack, and then you want to use it? It becomes public information after that through WikiLeaks, and they want to use it in either arbitration or anything for that matter. Can you do that or not?